don't know how many, we don't know how much, we don't know when it was happened.
Well, Judge, I don't think that's necessary to provide probable cause for the case. He's admitting to drinking, he's got odor of alcohol in the breath, and the accident itself is evidence of intoxication, Judge. All of that, in our opinion, is enough for probable cause.
I don't think so.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Today's video is going to take us in a little bit of a different direction. We're going to feature a channel called Vicky's Court Watch. Now, some of you that are more like courtroom oriented may have already seen Vicky's Court Watch. I know she displays a lot of like Zoom type court proceedings. I don't watch the channel a lot, and I've never highlighted her channel, but channels like hers and like A&E and Law and Crime and channels like that have brought us sort of inside the courtroom and really allowed people to see, sometimes for the first time, what the inside of a courtroom actually looks like and how things actually work. But for now, what I want to do, and the reason I want to show you guys this particular video, is because this is Judge laying down the hammer on police officers who are doing incomplete and non-satisfactory report writing for the purposes of establishing probable cause when they arrest somebody. So I want to open it up real quick, and we're just going to watch. There's 4 different cases, and we'll talk about what actually is going on there, and then we'll close it out after we have a little bit of fun watching this. So with that, let's check out the video, and we'll come back and talk in a minute.
Let's roll, nerds.
Good morning, Your Honor.
Hey,
How's it going?
it's been a while. How are you? What's
Doing all right.
new?
Yes. It's gas.
I'm right. Thanks. Good morning, Mr. McCaskey. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Just please don't say it. Okay.
October 26th, officer was dispatched to a major crash in Harris County, Texas. Upon arrival, the officer observed the defendant sitting in the driver's seat of his motor vehicle with his keys in his lap and with an odor of an alcoholic beverage. The defendant stated he drank prior to driving. Standard field sobriety tests were performed. HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4.
Okay, so when they're talking about these fractionalized numbers, when they say HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4, they're talking about the 3 standardized field sobriety tests, which I know probably most of you guys know, but just for the benefit of somebody who doesn't know. So HGN stands for horizontal gaze nystagmus. That's the involuntary movement or bouncing of the eyes. The walk and turn test is where you take 9 heel-to-toe steps in one direction, make a turn, come back 9 more. And then the one leg stand is obviously where you look at your toe and you hold your leg, 6 inches off the ground, and you're supposed to count to 30 seconds, or you're supposed to count until the officer tells you to stop. Each of those tests has like clues that the officers are supposed to be trained to look for. And there are certain things that you're not supposed to do during the test. And if you do them, those are considered clues. And that would indicate that you are impaired according to the junk science that is the field sobriety test. So HGN has 6 clues, walk and turn has 8 clues, one leg stand has 4 clues. So that's what they're going through right now. So let's get back to it.
The DIC was read and the defendant consented to breath, but the defendant was unable to do the test. A blood warrant was then signed and executed.
It was really quick. So where was he?
So it was a major crash in Harris County, Texas, specifically on 2201 Southwest Freeway.
Okay, and then what?
The officer arrived and he was in his driver's seat, and the officer observed his keys in his lap, and then he observed an odor of alcoholic beverage.
Just an odor. Anything else?
And then the defendant made a statement that he drank prior to driving.
Yeah.
And that's it.
Leads you to believe that he's drunk. We have an accident, I get it, but there's just an odor of alcohol. There's no slurred speech, no bloodshot eyes, just an odor.
Yes, sir. All that was written was the odor was observed, and then the statement made about him drinking.
McCaskey, I have an accident. All I have is an odor of alcohol. What can you, other than the accident, what can you lead me to believe that he's drunk or intoxicated?
The defendant stated he drank prior to driving.
Okay, there's a really important thing happening right now with the defense lawyer. And it might be hard to understand without somebody pointing it out to you, because he's actually not doing a single thing at all except standing there. And that is a telltale sign of a smart lawyer. And I know people are going to be like, oh, I know 2/3 of the audience hates lawyers, so that's fine. I understand. I hate lawyers too. It's not a big deal. But a lawyer with a little bit of experience knows when to shut up. And this is one of those times where you shut up. And the reason is because the burden is on the state. The prosecuting attorney has the burden of proving whatever level we're at, and we're at probable cause here. So the prosecutor has the burden of proving that probable cause exists for the arrests. And the judge is pretty vigorously going at the prosecutor here saying, hey, look, I got some questions that I don't have answers to. This lawyer is not saying a word. And it's because you learn that you should shut up when things are going your way, and you don't want to say something that will draw the attention of the judge towards your client so that he stops doing what he's doing, which is grilling the prosecutor and making obvious that he's leaning in your favor. So you can say too much as a lawyer, and it's a good skill to learn when to just allow your client to win without you actually advocating or doing anything.
We don't know how many, we don't know how much, we don't know when it was happened.
Well, Judge, I don't think that's necessary to provide probable cause for the case. He's admitting to drinking. He's got odor of alcohol in the breath, and the accident itself is evidence of intoxication, Judge. All of that, in our opinion, is enough for probable cause.
I don't think so. I mean, usually there's a lot more than just that. An odor, we don't have anything else. I don't know when, I don't know how many, I don't know how strong it is, just an odor.
Not every case has extrapolation or admissions of how many, Judge.
I understand
It's
this.
just
I
probable cause.
understand, Michael, but I need just a little bit more than just an odor and an accident.
An admission to drinking, Judge?
Okay, we don't know when. The officer can't do any more questions than that. Okay, when did you do it? How many did you have? Did you have anything to eat?
Understood.
The reason I wanted to show this is because very, very, very few judges do this. And they should. Every single one of them should do this. Probable cause is not a rubber stamp. There is a standard. Now, granted, it's hard for even Supreme Court justices to articulate what the standard is, but there is a standard for probable cause. And that is that a crime was very likely committed, and this person is the person who likely committed the crime. Just saying that a person was in an accident and just saying that a person had an odor of alcoholic beverage on their breath does not mean that they have committed a crime. You can have odor of alcohol on your breath and not be legally intoxicated. There's an evidentiary standard called totality of the circumstances that comes into play in a lot of different cases, but specifically with DUIs. And that's why the judge is asking these questions. Well, do you have slurred speech? Do you have bloodshot eyes? Do you have anything else besides odor of alcohol? That's one thing. The crash is one thing. Admitting that you drank is one thing, but we need more. There's reasonable suspicion to do an investigation, and that is what Judge Fletcher is trying to get the prosecutor to understand. When you have odor of alcohol, and you have a person that's in the driver's seat, and you have a car crash, and you have a person admitting to drinking before they drove, that is an invitation to investigate more. It's called reasonable articulable suspicion that the person is DUI. The police officer's job is to investigate, to use, as I've described it before, that on-ramp to probable cause by asking some questions, by doing some things, not just hooking the person up and then deciding that you're going to take them to jail for DUI, thinking that the judge is just going to rubber stamp it. So I'm really happy that he's doing this. Not everybody has the same body type. You know, I'm a big guy. When I drink 6 beers, it's going to impact me differently than a person who weighs 120 pounds. Or a person who's had bariatric surgery who might be still 250 pounds, but they have, you know, what's sort of jokingly referred to as straight pipes. And so when you drink, the alcohol goes into your bloodstream faster if you've got a bypass surgery or some sort of bariatric surgery that you've had. Those things matter. People have different body chemistry. People have different tolerances. And so the idea that just somebody saying, yeah, I had a couple drinks and yeah, I smell, that's not enough. And I'm glad that this judge is holding their feet to the fire on that.
Mr. McGaskey, it's very possible that they take it to a grand jury and indict it. But so I would be on the lookout, number one. Number two, you know how many accidents and death we have every day due to alcohol and getting into a car? I'm going to find no probable cause. Just take a seat for a moment. Thank you, Mr. Jeff.
At the end, he gives the defendant a tongue lashing just to say, hey, look, you know, if this don't look good, go on and sin no more, right? And he also tells them something very important. A lot of people don't understand this. In my Phoenix video and in a couple videos that I've done, people have said, well, the judge should be held accountable. Guys, listen. The judge does not have any more information at a probable cause stage than the parties give the court. When you are looking at probable cause, in most places, now some places are a little bit different, but in most places, you have a lower level, which is the probable cause level. In Tennessee, we call it the General Sessions Court. And that's where you're initially brought up on charges. The entire proceeding builds towards a probable cause hearing. Once that probable cause hearing happens and the judge says, yes, I believe there's probable cause, or no, I believe there's not probable cause, that part is over with. And if the judge finds probable cause, they do what's called binding the case over to the grand jury. That's saying, hey, look, this is basically like a rubber stamp for the grand jury. The judge found probable cause. We're going to put those facts in front of the grand jury, and the grand jury is going to issue an indictment. In the American criminal justice system, a person is not formally charged with a crime until they're indicted. And that matters because in a lot of states, Tennessee is one of those states, you do not have the right to full discovery as a defendant until you've been indicted. And so the other thing that can happen is that the judge could do what Judge Fletcher did here and say, I find no probable cause, and dismiss it. But that does not end the case in most states. In most states, the district attorney has the right to take all the same information they put before the judge and put it before the grand jury and allow the grand jury to make a finding of probable cause also. The judge and the grand jury have the same function. They're just there to look at the evidence that the prosecutor gives them to determine, based on that information alone, whether or not it is likely that a crime was committed and whether or not it's likely that this person did it. This is not the stage for evidentiary rulings for the most part. It's not the stage for deciding what's too prejudicial, what's not, what's hearsay, what's not. Not very much of that stuff comes into play at this stage. We're only trying to decide whether there's enough here to move this case in front of a grand jury and essentially burden the taxpayer with a trial. That's essentially what we're trying to do. This is all the information the judge gets, whatever the prosecutor decides to give them, and then whatever the defense attorney draws out in the course of cross-examination. That entire little closed universe of information is all the judge gets. It's not like a trial judge where they have all of the discovery at their fingertips. They don't know anything that the prosecutor doesn't tell them and that the defense attorney doesn't bring out through the hearing. So I'm not defending judges. I'm just saying that sometimes they get a little bit of a pass because they don't have the ability, even a mechanism, to find out the information and still remain neutral and detached. So let's see whether Judge Fletcher has a consistent approach with the next case.
All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65-mile-per-hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then
So this is the second case in a row where Judge Fletcher has stopped the prosecutor and said, no, you're going way too fast. Back up. Now I've got some questions about what's going on here. That's really good. It's not just I'm just going to let this thing go and I'm going to find probable cause. I want to know what happened. And this is really good. I'm glad he's doing this.
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank 2 beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the Sims, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk and turn, the one leg stand. He also noticed that I think she took off her boots for the one leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, an odor, not even a strong odor at that, and then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? There's no accident here. There's no, is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
Judge Fletcher being consistent here. He doesn't like these bare bones reports by these police officers and that they operate under this assumption that the court's just going to rubber stamp their probable cause statement. I'm really liking the way that he handles, at least for DUIs. This is the first time I've ever watched any of his videos doing this. I really like the way he handles these.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
far as I can tell, the officer also just demonstrated it to her, I mean, which is per,
But
The procedure for
right, I get the
SFSTs,
SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
Seems that this stop occurred at 2 a.m. and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period clean when she's finished
Yeah.
drinking, and then
Alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
she still had the odor in addition to that statement.
All right, I'm gonna find no probable cause.
Yes, Judge.
Ma'am, be careful, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push one button, you have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
Right, please take a seat.
Okay, I talk about this a lot in my DUI videos, and people always, they're usually dipshits, but they always give me a hard time in the comments. They're like, no, if you do that in this state, you're going to have to do it. Guys, listen. The judge just told you. A lot of people just don't understand this concept. They've been convinced over the years that you've got an implied consent, and by God, if you refuse to do field sobriety tests, you're automatically going to lose your license. If your lawyer has told you that, you need to fire them. Okay, because that's not true. DUIs are one of the most uniform standards across the country because of the fact that the federal government controls the purse strings. So almost all of the stuff is very close or identical in its language. You must build the case as a law enforcement officer before people can be penalized for refusing to play the game. And field sobriety tests are voluntary everywhere that I'm aware of. Now, if I'm wrong, show me something in the law. Don't give me some opinion that is just based on your feelings. Show me something in the law and I'll read it for myself and try to figure out whether or not that's true. As far as I know, field sobriety tests are voluntary everywhere. And as the judge indicates, you don't even get to ask someone or try to penalize someone for not taking field sobriety tests. Because we all know what happens. When they say, no, I'm not going to take them, they immediately get hooked up. So if you stop your inquiry there when they say no, and you haven't built this thing from reasonable suspicion up to probable cause, you've just tanked your DUI case. So if the officer stops somebody and they reasonably suspect they've been drinking and doing all these things, and they start this preliminary investigation, if they jump too early to the field sobriety test and that person has enough wherewithal to say, no, I'm not doing it, the officer's case is tanked if they decide then to try to arrest them. And in this particular case, you just heard a search warrant was sought for their blood and it was obtained. And what's going to happen is, regardless of what the results of that blood test was, this judge is on record now saying that this case was not built probable cause to the point to where they could even ask him for field sobriety tests. People always give me a hard time about this in the comments. You must build the case. It is not as simple, no matter what they've convinced you of a police officer just saying you have to do this and then you have to do it and you automatically lose your driver's license. And I don't care if you got a CDL, none of that too. I was the CDL prosecutor. It's not true. It's not true. They have to build the case before it triggers your requirement to do anything. And then you still don't have to do field sobriety tests. Now, if there's been probable cause established, then you have to give your blood or breath. And if you don't, then your license gets suspended. But the judge will determine after the fact whether or not there was sufficient evidence, just like Judge Fletcher's doing right here, to determine whether you were required to do that. That's what I'm trying to say. Like, it's not just the officer asked and I signed this paper and he read it to me and it's end of story. That's not where the analysis ends. You go back and look at the evidence before you determine whether that person had an obligation to give their blood or breath in the first place. And then if they were forced to do it, even through a search warrant, if the case was not built to the point to where they were obligated to do it under the law, then all that gets suppressed.
You are Keon Shaw.
Yes, sir.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 27, 2024, officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
The officer, he was originally traveling at an unsafe speed exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
Nothing's unsafe to me.
he began driving according to the officer in a suspicious manner, making sudden turns and then stopping on the side of the road.
Judge Fletcher says nothing's unsafe to me, and I don't know. There's something about his personality. I think he probably just hauls ass everywhere he goes. He just strikes me as this like kind of rebellious, cantankerous kind of guy. But I like this because in Tennessee we have an evading statute that says basically that if, and the language is after being given any signal from a law enforcement officer, if you choose to evade and you're in a vehicle, that's a felony in Tennessee. But a lot of police officers, they'll be going the other way, and then they'll turn around, and the person will speed up. And they'll speed up, and the police officer will lose them, and then they'll know who it is, right? It's usually somebody they know don't have a driver's license, whatever, but they didn't get turned around fast enough on them to turn on their lights. So you've got a police officer that's like back here, and then there's like a hill right here, and the person's on the other side of the hill. The police officer turns on their lights back here. The person at the bottom of the hill over on the other side can't see that. And the officer can't testify that that person was ever aware that they were even trying. Of course, the person probably knew when they saw him U-turn that they were coming after him, but that's not the same. That doesn't satisfy the elements. The elements are that you gave them a signal to stop, i.e. you turned on your lights, you turned on your siren after you were within eyesight of them and they knew you were trying to stop them. Not they anticipated that you were going to stop them, not I thought that he thought that I knew that he knew that I knew that he knew I was going to stop him. That's not a crime. And so I like that Judge Fletcher here, he's like, what did he do that was illegal? There's no speed that's unsafe for me. Why are you're going to, first of all, it doesn't sound like you have a good traffic stop because you don't even know how fast he was going. But on top of that, you want to charge him with fleeing and eluding because he decided to avoid you. He didn't do anything illegal. So it's not just DUIs. Apparently Judge Fletcher is a scrutinous judge, and I like that. I think it's respectable.
And then getting back on the road once the officer passed. So
Anything illegal with that?
I believe it would just be the speed limit would be the point at which the officer.
It's a conclusory statement. We need to have like a workshop on how to write ORs, man, for real. Everything in this office report is conclusory, suspicious, aloysius. Is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure.
DMs.
Let's do this. I'm going to have them because I want to make sure if we find probable cause that it's really there. All right. So just hang tight for me. We're going to have to do a little deeper dive. If you just mind taking a seat for me momentarily. Okay. Okay. Don't leave, Mr. Shaw. Jaramillo Jimenez, you were charged with driving while intoxicated. You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On October 28, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it operate without all of its lighting equipment activated during the nighttime. Upon contact with the defendant, who is the driver and sole occupant, officers observed the suspect to have slurred speech, bloodshot eyes, and an odor of alcoholic beverage. Defendant admitted to drinking 2 alcoholic beverages about 1 to 2 hours prior. SFSTs were conducted, 6 out of 6 HGM, 7 out of 8 walk and turn, 2 out of 4 one-leg stand. DICs were read, but breath was refused, and a search warrant was signed and executed. The defendant does also not have an eligible driver's license, Judge.
Again, we have to go on an offense writing report, just class. I mean, it's completely conclusory. Read me the first sentence. Why the PC for the stop?
Read from the DIMS really quickly, Judge. I just want to make sure
Shh.
it's correct.
Without all of its nighttime equipment on, what on earth does that mean?
See if we can read it from if we have the offense report, Judge, because that's what
It's
it's DIMS.
over and over and over and over. I mean,
Bicycle or?
headlights, brake lights, turn lights.
Fog lamps, my favorite kind of light.
Okay, so you got 3 cases that are DUIs and 1 case that's fleeing and eluding, and Judge Fletcher has smacked all of them down for probable cause. And he's talking about, when he says OR, he's talking about offense report. He's saying that a police officer doesn't even feel compelled to write a complete and thorough offense report. Now, I will tell you there is some strategy to that they teach you when you're in law enforcement training, and that is that you should only write in your affidavit whatever you need to establish probable cause. The problem is they don't do a good job by teaching law enforcement officers what it actually means to establish probable cause. We see it every day on YouTube. We see that they don't know when they have reasonable suspicion. They don't know that they have to build reasonable suspicion to probable cause, and they don't know what probable cause actually means. So the idea that you tell a police officer, well, don't give us any more than you need for probable cause, because again, like I explained earlier, you're not entitled to the entire discovery of the case in most places until you're indicted. And so there is a strategy to not giving you all the information, and it's not a Brady or discovery violation until there's actually been an indictment. And so they don't give any more than necessary to establish probable cause. The problem is that there's been so many corners cut with these police officers, and there are so many judges out there that rubber stamp anything that they do, and they don't ever get challenged by the court system, that this is what you kind of end up with. And so Judge Fletcher's basically saying, whoa, we've got to change this. If for no other place, at least in my courtroom, this is going to stop. And so I really like that he's going to take that proactive, prophylactic approach to trying to fix this problem with police. Now, you and I both know all they're going to do is make stuff up to fill in the blanks, but still, the judge can only do so much. In closing, the reason I wanted you guys to see this video is because, again, I get a lot of people in the comments that are always sort of challenging the idea that you have to build this from the ground up in a DUI case. And this is a perfect example of a judge doing what they should do and saying, whoa, wait a minute. We don't start at a level 5 out of 10, guys. We start down here at 1 and we build it. We build a set of stairs till we get up here. And if you don't do that, you don't have a good DUI case. And in most states, there's a separate process for a license suspension and a criminal offensive DUI. And in most of those places, the difference is an administrative law process happens for the driver's license suspension through the DMV, and the courts and the criminal justice system will handle the DUI. So you'll have a lot of people that end up losing their driver's license because there was probable cause built in order to trigger their requirement to do the blood or breath test, but they declined, right? So they lose their driver's license, but they ultimately, that gap between probable cause and proof beyond a reasonable doubt was never met, so they end up winning the DUI, the criminal part of it, at trial. So you'll have people out there that don't have an actual criminal DUI conviction, but they have lost their driver's license for a year because they didn't do implied consent. And then you'll have cases where both the DUI and the license suspension fails on probable cause grounds because the DUI is still going on, and they get to the probable cause stage of the administrative hearing, and they're like, we don't think that you met probable cause in order to require this person to give blood or breath. It happens all the time. You can look up the cases. There's all kinds of cases like that. Just look up case law on implied consent, and you'll be able to tell there's a separate process for that. So I thought it was important for you guys to see a judge in action that actually seems to take seriously the parts of the DUI process that are supposed to just be more than a rubber stamp, that are supposed to have a serious inquiry attached to them. Anyway, that's all for this one, guys. I hope you got something out of it. If you'd like to support the Southern Draw Law channel, I don't do any types of memberships. I'll leave my Venmo and PayPal links here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Specifically for this video, I'm going to leave information in the end cards that will link you back to the other DUI videos that I've done. That way, if this is the first time that you're seeing my channel, or this is the first time that you've seen a DUI video that I've done, you'll be able to sort of cross-reference that information that I've talked about in my previous videos. But until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.